18 Llave vs Republic and Tamano. GR number 169766. March 30, 2011. Facts. Around 11 months before his death, Senator Tamano married Estrellita twice, initially under the Islamic laws and tradition and under a civil ceremony officiated by an RTC judge at Malabang, Lanao del Sur. In their marriage contracts, Senator Tamano's civil status was indicated as divorced. Private respondents Haja Putri Zoraida A. Tamano and her son Adib Ahmed A. Tamano. Adib filed a complaint with the RTC of Quezon City for the declaration of nullity of marriage between Estrellita and Senator Tamano for being bigamous. It was further alleged that since Zoraida and deceased were married when the NCC was already in effect, the subsequent marriage to Estrellita is void ab initio since divorce is not allowed under the NCC. Moreover, the deceased did not and could not have divorced complainant Zoraida by invoking the provision of PD 1083, otherwise known as the Code of Muslim Personal Laws. For the simple reason that the marriage of the deceased with complainant Zoraida was never deemed, legally and factually, to have been one contracted under Muslim law. Instead of filing an answer, Estrellita filed a motion to dismiss. The trial court denied Estrellita's motion and asserted its jurisdiction over the case for declaration of nullity. Thus, Estrellita filed a certiorari petition before the SC questioning the denial of her motion to dismiss, which was referred to and subsequently denied by the CA. This prompted Estrellita to file a petition for review on certiorari before the SC, GR number 126603. Subsequent to the promulgation of the CA decision, the RTC ordered Estrellita to present her evidence, but she asked for postponement. Unhappy with the delays in the resolution of their case, Zoraida and Adib moved to submit the case for decision, reasoning that Estrellita had long been delaying the case. Estrellita opposed, on the ground that she has not yet filed her answer as she still awaits the outcome of GR number 126603. The RTC rendered the aforementioned judgment declaring Estrellita's marriage with Senator Tamano as void ab initio. On appeal to the CA, Estrellita argued that she was denied due process as the RTC rendered its judgment even without waiting for the finality of the decision of the Supreme Court in GR number 126603. The CA denied the appeal as she was given ample opportunity to be heard but simply ignored it by asking for numerous postponements. Hence, this petition issue, whether or not the Estrellita was denied due process, whether or not the marriage of Estrellita and Tamano was bigamous. Ruling. A new law ought to affect the future, not what is past. The marriage between the late Senator Tamano and Zoraida was celebrated in 1958, solemnized under civil and Muslim rights. The only law in force governing marriage relationships between Muslims and non-Muslims alike was the Civil Code of 1950, under the provisions of which only one marriage can exist at any given time. Under the marriage provisions of the Civil Code, divorce is not recognized except during the effectivity of Republic Act No. 394 which was not availed of during its effectivity. As far as Estrellita is concerned, Senator Tamano's prior marriage to Zoraida has been severed by way of divorce under PD 1083, the law that codified Muslim personal laws. However, PD 1083 cannot benefit Estrellita. Firstly, Article 13(1) thereof provides that the law applies to marriage and divorce wherein both parties are Muslims, or wherein only the male party is a Muslim and the marriage is solemnized in accordance with Muslim law or this code in any part of the Philippines. But we already ruled in GR number 126603 that Article 13 of PD 1083 does not provide for a situation where the parties were married both in civil and Muslim rights. Moreover, the Muslim Code took effect only on February 4, 1977. And this law cannot retroactively override the civil code which already bestowed certain rights on the marriage of Senator Tamano and Zoreta.